District of Columbia Law on Security Deposits.
What is a security deposit?
A security deposit is an amount of money paid by a tenant to a landlord to provide protection to a landlord in case a tenant fails to meet the obligations in the rental lease. Security deposits in general.
If the landlord requires a security deposit, the security deposit shall not exceed an amount equivalent to the first month's rent and shall be placed in an interest-bearing account. The landlord must also post notices at least annually stating where the security deposit is held and the prevailing interest rate for each 6-month period, and provide a tenant who is moving out with the same information as above, but for the duration of the entire tenancy.
You're ready to move out, but you want to ensure you receive your full deposit back. Here are the steps to follow. Step 1. Provide your notice of intent to vacate in writing.
Confirm the notice of intent to vacate requirement in your lease. Often 30 days is required, but sometimes a longer notice is required depending on the lease language.
Verbal notice is not enough. Provide written notice and send it by certified mail, email, or a text message.
Keep a record of your landlord's receipt of the notice to prove it was received. Even a signature on a notice to vacate form will do.
Provide a forwarding address, otherwise the landlord won't have a way to send your security deposit back.
If you are not sure about your lease's notice of intent to vacate requirements, contact the Office of the Tenant Advocate at 202-719-6560.
Don't leave any loose ends.
When you provide your notice of intent to vacate, ask your landlord for the current balance on your account so there are no surprise deductions after move out. For unpaid fees. If you don't know your forwarding address, provide the address of a trusted friend or relative. When you do have a forwarding address, you can provide it later.
Step 2. Remember to clean everything.
Common areas tenants forget to clean and could be charged for. Inside of appliances like ovens and refrigerators. Bathrooms. Dusting or sweeping around the room. Remove everything, even coat hangers and cleaning supplies, otherwise you may be charged for trash removal. If anything is broken, report it as a maintenance request well before you move out.
Step 3. Document everything. Take photos and videos after cleaning. Open appliance doors, drawers, etc. in your video to demonstrate cleanliness. Record the date and time to prove the cleaning was sufficient when keys were returned. When taking video, narrate what you are filming. Schedule walkthrough with your landlord if possible. Your landlord may be able to tell you what to expect regarding any charges assessed. Schedule the walkthrough a few days before move out to give yourself time to correct something that might be charged later.
What kind of repairs and damages can a landlord not charge you for?
Landlords cannot deduct charges for ordinary wear and tear from a tenant's security deposit. Ordinary wear and tear means deterioration that results from the intended use of a dwelling unit, including breakage or malfunction due to age or deteriorated condition.
What kind of repairs and damages can a landlord charge you for?
A landlord cannot charge you for scuff marks on the wall, however, they can charge you for holes in the wall. The landlord may charge for carpet cleaning or replacement if stains cannot be removed, depreciated value only.
Step 4. Security deposit return timeline.
After move out, the landlord has 45 days to either send the security deposit in full or send written notice to the former tenant that deductions will be made from the deposit. If deductions are made, then the landlord has an additional 30 days to send the remainder of the deposit, if any, along with an itemized list of deductions.
How to recover your security deposit if your landlord improperly withholds a portion or all of your deposit.
Send your landlord a demand letter requesting the return of your security deposit. Include in your letter the applicable District of Columbia law listed below. District of Columbia Official Code Section 42 to 3502.17. Security Deposit. District of Columbia Municipal Regulations, Title 14, Sections 308 through 311.
How to recover your security deposit if your landlord improperly withholds a portion or all of your deposit.
If your landlord does not comply with your demand letter, you can dispute the return of your security deposit in small claims court up to $10,000. If you lived in the apartment longer than 12 months, you are also entitled to interest on your deposit. Note, if the court finds that your landlord acted in bad faith, you are entitled to treble damages. Treble damages means that the landlord must pay 3 times the actual or compensatory damages. In other words, the landlord would have to pay you 3 times the amount in dispute.
If you have questions or concerns regarding the District of Columbia's laws on security deposits, please contact the District of Columbia Office of the Tenant Advocate. We are located at 2000 14th Street Northwest, Washington, D.C. 20009. You can call us at 202-719-6560. You can also find us online at www.ota.dc.gov.